can hear you very well, me too. Glad to be here back again. I think I did get dropped off, but let's try again. Do we have callers?
Yes, we do, and do want to, take a moment to thank our listeners to be patient there because they are trying so since morning today, and I'm glad finally we are having you on the air and we have our calls going. All right, to our first caller, Financial Radio, you are live on the air. Go ahead and ask your question to Pallavi, please.
Yeah, hello Pallavi. I have a question for H-1B clock reset. So, I was on L-1B visa and I exit from USA on 9th April 2012. Then I back again after 19 months and entered in 9th November 2013 on H-1B visa.
Got it.
So, will this reset my clock?
So the fact that you came in on a fresh H-1B in 2013,
yes.
Correct?
Yes.
Yes, and your stay outside of the country for over 12 months did reset your clock.
But I mean, what my attorney is saying, it will depend on the date of applied, because they said you applied on 1st April 2013. That will not complete 12 months. So will the date of applied matter?
No, so if you had stepped out of the country and you were out of the country, as I heard, for 19 months, that did reset your clock. And then when you use the quota, even if you were applied for in a year previous, but you enter the country, then you do get that fresh 6 years.
Okay, so if we are entering through the H-1B gap, it will provide the fresh 6 years.
Correct, but only if you have had a stay outside the country for over 12 months.
Yes, I had.
Yes. So then yes. The answer is yes, you will have the 6 years from the time you enter the country.
Okay, thank you.
All the best.
Hello. One more thing.
Go ahead.
Hello. Yeah.
Yes, go ahead.
Can I see the rules somewhere in USCIS website?
Well, no, it's not. So a lot of it, and that's why there are a lot of attorneys that do practice immigration. The rules are not clearly stated. All rules pertaining to this should be in 214H, and that's where you, in the CFR, that's where you should be able to see it. However, in the INA Act 101, and that would also be under H, but the rules are not that clearly written, so a lot of it is how you read them and how you practice them and what the practicality of all of those rules are. A lot of this is also subject to interpretations and policy memos by the government that are also not that easily available on the net for people to read. So, and that's the reason, I guess, immigration attorneys do provide that interpretation. The reset comes from the fact that there were 365 days that were spent outside the country and that you were subject to a new cap under which you entered the country. So when you were subject to a new cap and you had to re-enter the country, the time previously spent on the L-1B is discounted. It does not matter anymore. And that's something, if you have a different opinion on this, please have the lawyer again check this out, because that is the accurate interpretation of what the government allows, and we have successfully done it for many people.
Okay, thank you very much.
All the best.
Thank you for your call. 972-235-5555. Number in the studio. Going to our next caller, Financial Radio. You're live on the air.
Yeah, this is Zohair from Immigration Voice.
Hi Zohair, welcome to the airwaves. How are you?
Yeah, hi. Yeah, thank you very much. So, I had an update.
Okay, go ahead, please.
So the update is that Aman did a call too, and we learned a lot about things going on behind the scenes. But the short update is, we need to energize our folks again back on the bill. We might have a small bill coming up with technical fixes once this primary noise settles down. And we learned about the way the system is rigged against the employees or the skilled immigrant. And we need to just remain focused on the issues faced by people who are waiting on a green card for a long time, because not everybody is affected, and those who are affected, they are affected really, really badly.
Sure. So just on an update, and this is for everybody who doesn't know Zohair very well, he's a volunteer at Immigration Voice, and this is activism to make a difference in how the adjudication for the skilled workers happen. And there are a lot of people that have been waiting for their green cards, and they are subject to per country limitations. And Immigration Voice has been tirelessly working to try and remove those per country limitations so that the people that have been here, and some for over 15 years, would get a chance to be able to get their green card finally. Zohair, thank you so much for all the work that you do for everyone, because I know you are a green card holder already and almost a citizen now, and for you to go and speak for so many people does make a difference, because we need volunteers like you to make a difference.
Yeah, thank you. And Pallavi, we had 3,000 people on the call on Sunday.
All right. So there is a lot of interest because of the bad regulation that came out on the 31st of December that has not given that EAD that was promised by executive action by President Obama in November of 2014.
Correct.
Right. All right. Wonderful. Great going. Any other updates, Zohair?
No, the what Aman said was, if you sit over there and be in the shoes and listen to all the hearings and the way some other groups are saying that they represent immigrants, they are not really representing the people who are waiting on green card. They are representing their business, they are representing their companies, but they are not representing people of India origin who are waiting on green cards. And thank you, Ahluwalia Law Offices. At this point, I'll just let you go. Thank you.
Thank you. Thank you, Zohair.
Thank you on the behalf of the entire community here, Zohair. Thank you so much. And we will go to our next caller, Fun Asia Radio. You are live on the air. Go ahead and ask your question, please. You're live on yes, go ahead and ask your question to Pallavi.
Very good morning to you. Hello, Pallavi.
Oh, very good morning to you. How are you?
I'm good. Thanks for asking. My name is Sanjay Khetarpal. In 2012, my question is, in 2012, I come to US after marriage with an US citizen. But somehow the things not going good, and we get divorced after one and a half years. But I have some reports, police reports, and protective order, and some many more things against her. So every year I get an extension. I have extension on my passport. But on the last year they asked me to provide all the documents in August. I provide all the documents. Still, I have an extension for next year till February, but I don't get any reply from them.
Okay, so that I understand that you applied, looks like for a 751 for the removal of conditions from your green card.
Yes.
Based on the marriage to the U.S. citizen, and you had submitted your divorce decree, and did you argue that you had entered the marriage in good faith and it ended up in a divorce, or had you used extreme cruelty prong of the removal of conditions?
To extreme cruelty.
You did not modify it to do the good faith aspect, because the good faith aspect is the one that is the easier prong to prove. Has that been
but I don't get...
Hello.
Go ahead.
Yeah.
Hello.
Go.
But I don't get any interview, anything from their side. I'm getting extension only.
Yeah, so the extension is coming because they are not being able to decide whether there was extreme cruelty or not, and somebody is taking time to adjudicate your case that way. But once you had gone through, you did end up in a divorce, correct?
Yeah.
Okay, did you give the divorce decree in the papers that were filed with the 751?
Yeah.
You did?
Yes.
Okay, so the government does know that. Did you also give proof of the fact that you had entered the marriage in good faith, meaning you had a proper ceremony and everybody knew about this marriage? Did you put that information into? So yes, so if that's been put in there along with extreme cruelty, then you should not have a problem in getting this approved, but it may take a little while for the government to decide this. You could take an info pass and find out what's going on with this application, but if you were to get a request for evidence from the government, do treat it seriously, because in that request, sometimes the government lets you modify the prongs that you have chosen, and that may be the right way you want to go through it.
All right. Thank you so much. Thank you so much.
All right. Thank you for your call. 972-235-5555 number in the studio. This is Your Business Matters with Pallavi Ahluwalia from Ahluwalia Law Offices. Want you all to know, if you want to get in touch with her beyond the show, you must take an appointment to see her, and you can get that by calling 972-361-0606, ahluwalialaw.com, their website. Pallavi, you said you had something very important to share with our listeners. Do you think we can do that now?
Yes, absolutely. And this is the announcement that has come in for the STEM OPT extension. Now, everybody knows that the new rule was published. Now, the clarity on that has happened this past Friday. The U.S. Department of Homeland Security has published an amended regulation on optional practical training for certain international students. And these are the ones that use the science, technology, engineering, or math, and they graduated with those degrees from U.S. institutions of higher education. The amended regulations are going to be going in effect from May 10th, and the ones that are pending still currently from the old applications will still continue till May 9th. On May 9th, they will automatically go into the new regulation, and if the new regulation requirements are not being met by the previous filings, then there will be a request for evidence that is issued to the student, and this is something that's out to the students. Take that request seriously, because the requirements on these extensions have changed now, and there are higher obligations in the training program that has been established. Now, there is also a new form that has to be filled out, and that is the form called I-983, and that should be, those sections have to be certified by the student as well as with their employer. So this is something that I just wanted to let the community know, because we're in the middle of filing H-1Bs this year, and we have a lot of STEM students also. So this is a question we are answering a lot more at our firm, and but do want the community to be aware of this when they're filing their cases.
All right, wonderful. And do want to point your website to all our listeners, because a lot of great information up there. And ahluwalialaw.com is the website, and all the recordings of the live shows are up there as well, just for your information. Going to our next caller, Phanisha Radio, you are live on the air. Go ahead and ask your question, please.
Hi Pallavi, this is Siddhaya. Good morning.
Good morning. How may I help you?
Yeah, I have a question with applying parallelly the H1 and H4. So I'm working with company A, and my wife got a chance to get the H1 from company B. So my company is applying H1 for me and H4 for my wife. And parallelly, the company B is applying H1 for my wife. Is it a good way, or we should hold on this H4 conversion?
I would hold off on the H4 till you all are selected in the lottery.
Okay.
Okay, so you both have independent status that you're maintaining, correct?
Yeah. Actually, right now, like, I am on L1 and she's on L2. Okay. So both are switching to H1. So.
Okay. So if both of you get selected in the lottery, there won't be an issue. If one of you gets selected in the lottery, then the other one can come in to the application as an H4 by using the receipt notice.
Okay. So that is not a problem, right? Later applying for change of state.
No, it should not be.
Okay. Thank you.
All the best.
Thank you so much for your call. 972-235-5555 number in the studio. We have exactly 4 minutes left. If you have any question on your mind, this would be the time to call. Going to our next caller, Phanisha Radio, you are live on the air. Go ahead and ask your question to Pallavi, please.
Hi Pallavi, my name is Sampath. I just wanted to thank you for helping out the community. I don't have any question.
Oh, that's so
how sweet of you. Thank you so much. I appreciate your call.
Yeah, listeners are really very expressive, and really thank you for that call.
Thank you. Thanks a lot, Phanisha, for hosting the call too.
Thank you, absolutely.
Thank you.
Going to our next caller, Phanisha Radio, you're live on the air. Go ahead and ask your question very quickly.
Hi, good morning. Thank you to giving me the opportunity to talk with the attorney. Thank you. My question is, if someone gets the H-1B, does he or she need to go to back original country to get the visa?
So the first time stamping on the H1 rule is home country. the consulates that are nearby, which is Mexico, Canada, or even sometimes the Caribbean countries, do allow that stamping, but only on a discretionary basis. On the first time stamping, the rule just requires you to go back and to be able to prove your credentials back there, especially if degrees that are Indian are being used for the purpose.
Okay, it's even the British citizens, so they need to go to England.
Yes, that's where they need to go for stamping, whatever the home country rule says.
All right, thank you so much. I really appreciate it.
All the best, of course.
All right, thank you so much. I think we can take a quick last call. What do you think, Pallavi?
You go to England.
All right, going to our last caller probably, Farisha Radio. You are live on the air. Do request you to turn off your radio and then ask your question, please.
Yeah, sure.
Yeah, go ahead.
I just got my labor approved, and my I-140 was actually filed in premium.
Okay.
And my question is, how long usually it takes for that? And then once the I-140 is done, my wife can apply for an EAD, right?
Yeah, once the I-140 is approved, yes, under the existing rule, the spouses, that was announced last year, spouses do get the benefit of getting EADs that rhyme with the length of stay that is also given on the H-4 and the H-1B.
Oh, okay. So usually how long does the premium processing take for the I-140?
So premium processing is supposed to be adjudicated within 2 weeks unless the government has extra questions, and if it does not issue the request for evidence. If it issues a request for evidence, that resets the time to beyond the 2 weeks to the time that they allocate to what they expect out of you in the RFE.
All right, I'd like to tell you both that we have just under a minute left. I guess it's time to wind up the segment. Do you think, Pallavi?
If the caller wants to hold on, I can answer the question of the...
Okay, I will hold on. The other question I had is how long the EAD takes.
All right.
Okay. All right. It should take 90 days, but let's hold on.
Yes. Okay. Thank you so much, Pallavi, for coming on air and doing the segment. Thank you so much.
Thank you. Appreciate you, as always, Meetu, for hosting me so wonderfully. And I'll come back tomorrow and we'll do another little segment and be able to answer more questions. We had some technical difficulty up front, and I'll take the call while the caller's off the air.
Excellent. Thank you so much, Pallavi. Talk to you tomorrow.
Bye-bye.
Bye.